Number 4, joint representation creates systemic fair notice problems. Defendant's joint representation has produced an answer where it is impossible to determine which defendant is asserting which defense, despite the fact that many defenses can only legally apply to one defendant, not both. This structural ambiguity creates systemic fair notice problems that permeate all 20 affirmative defenses. For immunity defenses, the city cannot claim qualified immunity under Owen, while individual defendants potentially can. Yet the defense is asserting collectively. The defense is asserted collectively without distinction. So that's exactly what we're talking about. Like we admit, or Tracy admits, that can potentially assert some immunity, but the city cannot, and they're not making a distinction in their answer. For Monell-related defenses, the city must argue acted outside of policy, while must argue he acted according to policy for immunity purposes. This contradictory position cannot simultaneously be true, yet both are asserted without specifying which defendant relies on which theory. 4.4. For damage-related defenses, municipalities cannot face punitive damages while individual defendants can, yet the punitive damages defense is asserted collectively. 4.5. The contradictions inherent in the defendant's joint representation create significant obstacles for the plaintiff in formulating a proper response. This issue extends beyond mere lack of detail to collective approach that obscures which defendant relies on which legal theory, resulting in the kind of unfair surprise that undermines fair notice principles. In Goodyear, the withholding of critical evidence similarly impeded the court's ability to resolve the case on its merits, highlighting the necessity of transparency in litigation to serve the judicial process's truth-seeking purpose. Such a procedural approach contravenes the principles that litigation should facilitate the clear presentation of claims and defenses. This court should promote pleading practices that support the just, speedy, and efficient determination of this action to ensure a fair resolution grounded in truth. So that's the one thing I think that a lot of people miss, is that this is a full transparency process. There is no be related in the middle of a trial, secret process that suddenly wins your case. That is not what happens in court.
Now, you can withhold evidence from defense if you're going to use it for impeachment. If you do not intend to use it for impeachment, then you have to provide it.
Or not use it at all.
Right.
So if you have impeachable evidence, you can withhold it. But if it never comes up to impeach the other side's...
Could you give an example?
Not off the top of my head. I can't think of an example. I know it's come up.
So you want to catch somebody in a lie. You know that they're going to lie on the stand. And you have evidence that would show.
Well, so it's not a straightforward example, but it is. So if you get an answer from, like in the pleadings, you have your claims, and then the defense is going to present their answer in response. And you look at these sworn statements, affidavits, and you're like, well, I know that's not true. I have evidence to show that's not true. Then under that condition, you can withhold that, so that if they stick with that truth all the way to trial, then you use that for impeachment during the trial. So that, and then the other side can't complain, oh, you had that evidence, you should have shared it. no, I wasn't going to bring that up. I was only going to use it for impeachment. And if you would have told the truth on the stand, then it had never come up, and there wouldn't be any problems because I don't intend to use it other than to show that you're a liar. So that is I think the only time you can withhold evidence.
And I would use it more to impeach a witness as opposed to like the defense brings a witness to the stand. You know that witness is going to lie, or you have evidence that can show that this witness is not credible. Then I would make sure that I have evidence to show that that witness that the defense is using is not credible.
Right. And I think some people want to show their cards immediately and like give a heads up to the other side. It's like, all right, I already have evidence that this guy's is going to lie, and then they can walk around it. You can correct the record. Like you can go back and you can amend your statements. You know, I got you on deposition saying this, and so you're before trial, and you say, ha ha ha, I got you lying. Like, you know, let me go correct the record. You make a correction to the deposition. You make a correction to your affidavit. So, but when like you got 3 depositions and a sworn statement all saying one thing, like, okay, let them stick with the lie. Let them stick with the lie. There's no need to call it out until trial.